And I'm going to get started with our first presenter, Carla Calogero. Carla has been with the firm for almost 10 years. She comes with not only her law degree, but also a master's in bioethics, and is a go-to person and resource for considering complex planning issues around that. And today's topic, though, that Carla will be presenting on is on planning considerations for young beneficiaries. So Carla, I'll let you get started.
Thank you, Mike, and welcome to all. I'm looking forward to today's program. I'll get us started with some discussion about estate planning considerations with young beneficiaries. We'll talk about some of the pitfalls that we see and some options when considering gifting for young beneficiaries. And like Mike said, we'll do Q&A at the end of all of the presentations. So first of all, who are young beneficiaries? Well, we certainly know that minors are young beneficiaries, and the age of minority in all but a few states in the country is under age 18. And the issue is that a minor cannot inherit property in their own name, which means that an adult or perhaps a professional fiduciary must hold and manage the property for the benefit of a minor until age 18. But young beneficiaries in our planning includes a larger class than just those under age 18. We think about young adults and planning for them and gifts to young adults. Then we ask the question, well, what is a young adult? And it depends a bit on the options that you're utilizing, but a young adult could be considered someone up to age 21, perhaps age 25, or even age 30 or 35, if we're talking about some trust for young beneficiaries. We are in the business of laying out for you worst case scenarios. So we'll talk first about what we, from our planning perspective, may consider some of those worst case scenarios to avoid. So issue that a minor beneficiary is named as a direct beneficiary. So as a direct beneficiary, this means they are named under your will. Perhaps they're named as a payable on death beneficiary for a life insurance policy. But a minor beneficiary may also receive as a contingent beneficiary class. So, for example, I give to my cousin Betty $100,000 or to her descendants if she predeceases me. Well, if Betty has predeceased you and she has descendants, and any of those are minors or young beneficiaries, there needs to be a contingent plan for those individuals. So if this occurs and there's no planning or protections in place through the options that we'll talk about, the court will become involved. Court intervention will be required. A probate guardian ad litem will be appointed to put plans and protections in place that you did not. One of the options here with a court-appointed guardian ad litem is a court-established trust, which will be court-supervised until at least age 18, or a conservatorship proceeding, guardian of the estate conservatorship will be established and court supervised until age 18. Or if the funds are somewhat modest, perhaps the court will just order that those funds will be held in a blocked financial account until age 18 with no access or use absent another court order. Another worst case scenario is trickle down gifting. So what I mean by trickle down gifting is that we assume that if I give to my daughter, Jane, that my grandchildren, Jane's children, will receive benefit from that gift to Jane. But that doesn't always occur. That is, the gifting doesn't always trickle down. And there are a number of reasons why it may not. I'll go through those briefly. So first, the beneficiary parent's estate plan is inconsistent with your trickle-down gifting intent. Perhaps they leave everything to a spouse. If they're married, there could be commingling of community and separate property between the beneficiary parent and spouse. And then what if a divorce occurs? Or what if the beneficiary parent dies before the other parent and the other parent's estate plan governs? And of course, remarriage can be an issue as well. Other issues while trickle down might not succeed, unknown circumstances. For example, creditors of the beneficiary parent or spouse, incapacity of the beneficiary parent or spouse, or of course, just waste or spend down by the beneficiary parent or spouse. So presumptive generational trickle-down gifting is not a good option. I'll discuss three options when you're planning for protections for young beneficiaries. The first option that we utilize commonly are trusts for young beneficiaries. Another option are what are called custodial accounts. And finally, 529 education accounts. So like all types of trust, a trust for a young beneficiary could either be lifetime or testamentary. If lifetime, you are establishing and funding the trust upon your life. It could be a trust for direct benefit of the beneficiaries, or they could be beneficiaries under your trust when you pass away. So if it is a revocable trust, that is a lifetime or revocable living trust, you retain control and ownership of the trust assets as long as you are alive and have capacity. If it is a lifetime irrevocable trust, you hand over control to a trustee and you make an irrevocable gift to the trust. Generally, this is undesirable except for tax planning purposes. And then most commonly, there is a provision in your will or your living trust to establish a young beneficiary trust upon your death. This is testamentary. So there are some very good things about pre-planning and establishing these trusts for beneficiaries, either during your lifetime or under your testamentary documents, because you decide. You decide the trust purpose or purposes. You decide who will be trustee and who will be successor trustee if they can't act. You decide the duration of the trust. Will it be in place until age 25, 30, 35? You decide the distribution standards and the structure for distributions. You decide what accounting and notice requirements you want to have in the trust. And of course, you get to decide who the remainder beneficiaries are of that young beneficiary's trust. So like I just described in the preceding slide, trusts for young beneficiaries enable you to have more control over the gift and over the distributions of the gifts during the beneficiary's lifetime. Generally, trusts are advisable for substantial gifts or inheritances. And I know you'll ask, what is substantial? Well, it is subjective, so discuss that with your attorney. And generally, they afford greater accountability and fulfillment of fiduciary duties with a trustee in place. Custodial accounts are a unique type of financial accounts, and they're often referred to as UTMA accounts, which stands for the Washington Uniform Transfer to Minors Act. Even though minor is in the title, these accounts can be maintained up to age 25. You decide. They are taxable investment accounts. The assets are considered to be owned by the young beneficiary, although the accounts are fully managed by a custodian who is not the beneficiary. A consideration for custodial accounts is that because they are considered owned by the beneficiary, they may impact financial aid. And like trust, you can establish custodial accounts during your lifetime or within your testamentary documents. If during your lifetime, it is considered, that is a contribution to the account, is considered an irrevocable gift, which means it won't be in your estate when you pass away. There are no contribution limits to custodial accounts, and they remain in place after your death. You just need to designate a successor to be custodian for the account. And if you're establishing custodial accounts under your will, you just need to identify that that's the mechanism and identify the custodian for the accounts for young beneficiaries. 529 accounts are another planning option to make gifts to young beneficiaries, and these are state-sponsored plans that offer tax-deferred growth. 529 accounts would be established by you during your lifetime, and that means you always want to name an account owner survivor in case you pass away during the lifetime of the account. 529 accounts have an owner, that would be you if you establish it, or the successor if you pass away, and a beneficiary. And as I said, the account owner controls the account. There are tax advantages to 529 accounts in that the earnings grow free from income taxation. There are some restrictions on 529 accounts, and that the disbursements from the accounts can only be for qualified educational expenses, but that is a large umbrella. That can be tuition, can be room and board. Really, the umbrella is quite large. If you make a distribution or take a distribution from the 529 account for non-educational purposes, there will be a 10% tax penalty. And getting back to another tax advantage of 529 accounts, they are considered a completed gift. That is, the contributions you make are, which means the accounts are not included in your estate at your death, but does use a part of your gift tax exemption at the federal level, if that may apply to you. Washington 529 accounts have a contribution limit of $500,000, and unlike custodial accounts, 529 accounts have less of an impact on financial aid. The impact should be no more than 5.6% to the financial aid package. In Washington, we have two types of 529 accounts. I'm sure you've heard of them. There's the Dream Ahead and the Gets accounts. So the Dream Ahead account is the 529 savings account. It's an investment account. And so contributions hopefully grow over the lifetime of the account, but are subject to fluctuations in investment accounts, and also have no inflation protections. Excuse me. The Get account, on the other hand, is a prepaid plan. You purchase guaranteed tuition units at a fixed price today, which means if you purchase the equivalent of 5 credits at a university today, you will get 5 credits paid from the Get account, even if 5 credits today is 1/10 of what 5 credits might be in 10 years in terms of the purchase price. And for 529 accounts, the owner does retain control over the types and the timing of distributions from the accounts. So just a few parting do nots. In general, do not assume that your current young beneficiaries will not be young when you die. Do not assume that a young beneficiary will benefit from a gift to their parents. Do not name minor or young beneficiaries to receive directly under your will or trust or life insurance policy, for example. Do not name minors or young beneficiaries as transfer on death beneficiaries on retirement accounts, life insurance policies, etc. But do name a trust on that beneficiary designation, a trust for young beneficiary under your will or that you have established during your lifetime. You may consider irrevocable life insurance trusts if federal tax planning is a dominant priority for you. Or you may name a custodian as to receive a young beneficiary's transfer on death benefit. But again, remember, the custodial account may only be in place up to age 25, and you have no control over what types of distributions the custodian makes. In parting thoughts, review your retirement account and life insurance policy beneficiary designations regularly, including now, and seek the advice of your estate planning attorney and your financial advisor, because of course, none of the information in this presentation is legal or financial advice specific to your unique circumstances. Thank you.